Motion to be heard. Everything that's titled motion within your suit, either as a defendant or plaintiff, must involve a motion to be heard. You can either implement it towards the end of your document or file a separate one. But there are different types of hearing, and that's what we're here to speak about. For you to be heard, you must comprehend that there are different types of hearing. In the past video, we entertained the subject matter of status report. Know that that status report is actually different from status hearing. A status report occurs independent of whether a status hearing has occurred or not. A status report can take place and be enforced regardless of whether a status hearing has existed or has taken place or has been participated. Status report is the final outcome of whatever took place publicly or privately, and you're just balancing it out publicly to let them know what's going on. As an example has been shown in that video regarding status report and settlement. That was just one instance, one example. But now we're speaking about the matter of hearing, which is, okay, what do you have to say about this? In some cases, you put things on pen and paper and you might be apprehensive that, okay, I don't want them to misconstrue one thing or the other, or I'm still gathering some evidence, because I would trust that you know that evidence is the backbone of all cases. It's been mentioned in videos on YouTube and here in several videos regarding court cases. You can cite all the case laws that you want. If you don't have evidence to back it up, it is as though someone is just looking at a blank piece of paper and then they're flipping a page and it's a blank piece of paper, and then they're flipping a page and it's a blank piece of paper, and at the end they just saw your signature. Here's a mistake a lot of people make. People think citing case laws, quoting case laws in your document, they think that is the core of it. Let me tell you, for every one case law that exists that you are aware of, there are at least 50 more that contradict that. It doesn't necessarily overturn that specific case laws, but it contradicts it in its entirety. Even if it's case laws within the same circuit, within the same district, and usually these case laws that contradicts what you are already accessing on the internet, these other 50 case laws that contradict it are not available to the public. And they will throw it out to you in cases. And you will now copy and paste it and look it up, and you will not find it and realize, oh, you need to be a signatory, or you need to be a member of some type of bar website or LexisNexis to be able to access it. For every one case laws that you are citing that you think gives you a right of claim, there are 50 more that contradicts it. The only thing that validate case laws that you cite in your cases are the evidence specific to your situation. The evidence that you introduce specific to your circumstance, not that of the other man or woman in that other case laws that you're citing. The evidence in your circumstance is what then determines the applicability of that case law that you are citing. Ever too often do people want to appear or sound like attorneys. And in fact, acting judges don't respect that. Acting judges snobs you when you cite case laws, because they know that all those case laws, there's a million more version of that says the opposite. Of course, a million is an exaggeration. The strongest suits are the ones that you explain your circumstance, because you are creating a res judicata. You are creating a case law with your active case. The moment you cite someone else's case law, you kill the validity of your own case. Now take the principle within other case laws and res judicatas. In another video, the difference between res judicata and stare decisis has been entertained. Res judicata, in summary, is just a situation that occurred with someone else that might be similar to yours. Stare decisis is the foundations, like maxims, to which case laws are created, and other types of bodies and language of laws are created. When you open a suit, they open a file number for it, a separate account, a separate case number. What that is telling you is that that case number, so-and-so versus so-and-so case number, blah, 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 dash so-and-so, that's a potential res judicata in the future. And you are doing it right here, right now. Why then limit your own options to what has occurred in the past? Simply take the verbiage and the principle and cite it verbally, but don't cite the actual case laws. If a case law defines unjust enrichment, type the verbiage of that unjust enrichment exactly as it is in that previous case law, but don't cite so-and-so versus so-and-so, because now you've confined it into a realm that they are masters at its playing field. The main problem people face is they feel something is done wrong. So they look at the internet and search for case laws that matches what they feel. In them doing so, they don't realize that they are deviated because those case laws actually steer you away. For instance, people who say that commissioners and acting judges in child support are being compensated in an unlawful manner. That's not your contention when it comes to money. Your contention when it comes to money is the fact that you don't have any contract with them for them to be taking money away from you. And that's unjust enrichment. The Fifth Amendment says that private property cannot be taken for public use without just compensation. Right here, according to the Constitution of Congress.gov/Constitution Amendment 5, Congressional website, no person shall be held to answer for capital crime, nor shall private properties, aka your monies, be taken for public use, aka these, quote, governmental entities. That says that they are governmental entities for the county or for the state, enforcing child support. Nor shall private property be taken for public use without just compensation. The moment they take your monies, garnish your checks from child support, they're taking your private property without compensating you because you are the loser in that situation. Your contention when it comes to money with child support should be lack of just compensation for the taking of your monies. And two, the rights and obligation of contracts. According to Article 1, Section 10 tells you, no state shall make law impairing the obligation of contract. Men will see how everything joins together. I specifically found this case law dealing with sequestration issues so I can correlate it with other matters that I know a lot of people are dealing with previous videos that we've done. There are a lot of motion for status hearing that you will find in different case laws. But I specifically took the time to find this one dealing with sequestration, which is the return of someone's money that was once taken. No difference than with you, with child support. A lot of people ask, well, how do I get my money back? It's called sequestration action. And then there are other things when you start to move for certain things within said action or any other regular complaint or bill, regardless of whether it's at law or equity, whatever it is you're doing, family court, whatever it is. Whenever you move in anything, sequestration case or not, you should always the complete 23-minute videos on the Patreon page. Take care. Best of luck.